Now, General Secretary of the Opposition NDC, Johnson Asiedu Nketia, is insisting no candidate won the December 2020 presidential election, saying that is the basis for the party's petition before the Supreme Court. He's, however, admitted during cross-examination today that the NDC did not attach any data to support the claim that none of the candidates reached the 50+1 threshold to win the presidential polls. Responding to questions from a lawyer for President Akufo-Addo Akoto-Ampao, the NDC General Secretary was unable to tell the real figures from the valid vote cast, since, according to him, the Electoral Commission chairperson kept changing the figures after the result was announced. Let's go right now to the court where Joseph Akabli, our correspondent, is standing by. Hello, Joseph.
Hello, Gifty. So proceedings just ended and you heard the news conferences that were addressed. I'm joined by Ediji Tamaklo. He's a member of Mr. Mahamet's legal team, one of the spokespersons actually in terms of the official statements from Mr. Mahamet's side. I mean, just to be clear, I mean, is your side satisfied in clear terms with what General did in the box today?
Extremely. In fact, the counsel for second respondent ended up doing our case for us. Quite clearly from the cross-examination, he admits that there were, in fact, in his own words, manifest error. I mean, when you say an election has been conducted and that there is manifest error, what else? And remember that at the core of this petition is the constitutional responsibilities of the Electoral Commission provided for under Article 63(3) of the 1992 Constitution. And that function is performed by only one person, the returning officer. In fact, it has been suggested by way of questioning in court today that the NDC should produce its own figures. That has never been the constitutional responsibility of a political party to declare its own result. That's for the EC. And through the lawyer of the second respondent, he admits that even the percentage allocations to the various candidates in the election were erroneously declared. Look at the Techiman South presidential election results. I mean, when have you seen this kind of election before? When have you seen this kind of election before? I mean, if we are going to have elections in this country conducted in this manner, then we should as well just forget this democratic experiment, where we'll be asking various political parties to produce their results. It has never been the case.
But if you are filing a case in court, I mean, you don't expect the court to do the mathematics for you. You should do the mathematics and make a case.
I mean, the General has said that plus or minus, we believe that the declaration on the 9th.
Yeah, but General, in terms of the videos that were played, there was one video where General makes the point that the elections are declared in polling stations across the country. The question Jasapa was trying to find out is that you have access to the pink sheets.
Remember that presidential election is one constituency.
Yes, but they are declared at the individual polling stations. They are declared at the individual polling stations across the country. And the question Jasapa was asking is that, as it stands now, does the petitioner know how many votes he actually obtained in the election?
You see, we are in court based on relief sought. Unlike the 2013 petition, where the petitioners then were asking the court to annul votes, and that when those votes are annulled, he will be declared president. Our petition is not. So it is obvious that there are certain misconceptions that had been carried from the 2013 petition into this very one. In this specific one, you notice that we are not even bringing polling station pink sheets as the basis of this petition. No. We are saying that on the 9th, there is a person constitutionally mandated to do declaration of presidential election. That person is called Jane Mensah. She, in fact, did a declaration on that 9th. That declaration, as we speak today, the result, she had been given different numbers to date.
Your colleagues hold the view that you know the truth, which is that when you put together the figures from those polling stations, you know that the president, i.e. the second respondent, got more than 50%. That is why you are not bringing that document.
Be correct. The declaration done on the 9th by Madam Jane Mensah, it cannot be correct.
And the declaration done across the country.
No, that is why I'm saying that even the second respondent and the first respondent, as we speak in court, they are no longer relying on the result declared on the 9th. They have run away from their own figures. Have you seen any election conducted in this country from 1992 in this manner before? Beyond the incompetence.
And another point we've seen in the last few occasions that the petitioner has not been coming to court. I mean, he should be following the case. I mean, is there any reason why?
No. I mean, because from the beginning he unveiled himself. He has other businesses to take care of, and like he said, he had worthy representatives. He's well represented by way of legal representation, and he's well represented by way of the party as well. The party's general secretary. In fact, you note that the running mate was equally and has always been in court.
Finally, we know that Dr. Michael Pesawait is your other witness. I mean, what is your own plan going forward into tomorrow?
He has always been around. We were thinking that today the cross-examination will be a bit more crisp, a bit more, straight to the point, beyond the, all over the place, But at the core of it is that Dr. Michael Pesawait is quite ready. He's been, hovering around, thinking that today will finish early so he can mount the witness box. Yes, sir.
And he's ready to mount the box?
In fact, he's a witness of facts. He was in the strong room, and he will come and tell the good people of this country the manner in which Jane Mensah treated the petitioner. Yes.
Thank you very much, Counsel. And so you heard Edudzi Tamaklo. He is one of the spokespersons for John Mohammed's legal team, the legal team that is handling this particular petition here at the court. Gifty.
Yeah, Joseph. It's interesting. I just want us to go over what has happened so far, and also hopefully to get some sort of reaction from the other side on what Mr. Tamaklo has just been telling you right now. But for the second respondent lawyers, and we heard Kojo Nkrumah speak there, it sounds like Mr. Chikata had a lot of work to do, as far as he's concerned. That Mr. Chikata had a lot of work to do because from his perspective, the witness didn't do such a good job.
That is the view that Mr. Nkrumah holds. He spoke on behalf of President Akufo-Addo's legal team, and as far as he's concerned, Mr. Seydou Nketia was exposed, and he said he's a general who was exposed badly, and he made reference to the 3 key questions that Justice Yawapel asked at the latter part of the proceedings. The questions relating to whether he knows for a fact how many votes the petitioner obtained by way of his own coalition, and the other matters that came thereafter in terms of that particular question. And so that is the view that the president's legal team holds. Unfortunately, they addressed the news conference first, yes, and right at the end of the news conference, they left the court premises. That is how come we were unable to get a reaction from them. So Joseph,
let me just jump in there.
The former president's legal team, they just finished addressing, and that's how come we're able to engage Edudzi Tamaklo.
Great explanation of that situation. It's really not a big deal. We've just been joined on the line by Mr. Kojo Nkrumah, who wants to respond to some of the concerns or some of the issues raised by Edudzi Tamaklo there. Joseph, so hang on for me. I'll be coming to you shortly. Mr. Nkrumah, good afternoon.
Hello.
Hello, Mr. Nkrumah, so thank you very much. The Edudzi Tamaklo makes a point that there is a fundamental problem when your lawyer, your counsel himself admits to, what was the description for it, the errors, the manifest errors that apparently was committed. For him, it's something that makes their case for them even.
But I'm not sure that the government of their case, essentially, is that there is an error simpliciter in the verbal articulation of the results as mouthed on the 9th. I'm not sure that that's where their case ends. Their case is to the effect that there is a mistake or there's an error, which error amounts, if you add the press statement to it, to vote padding, and that if you do the hypothetical calculation of Techiman South, we have to go for a runoff. Let nobody kid himself. Today, when Poch was put to shove, and now their star witness, Mrs. Johnson Nasiru Nketia, was put under oath, you began to see their case crumbling. First of all, as I mentioned earlier, our objective was to showcase to their learned or to the respected justices of the Supreme Court the fact that the witness in the box and the petitioner do not have credibility. And I think Counsel Akoto Ampao displayed that excellently by playing back to them their own claims in which, contrary to what they've been saying under oath, now in videos we are seeing them claiming that they had won this election, some giving figures of over 50%, that they had won about 10 regions, etc. Now, as we go into the number specific and give Mr. Nasiru Nketia the calculator to begin to calculate, however he calculates it, Nanado still gets 51% and over. Now, even these so-called, errors, if you look at the issues that have been set out, one of the questions is that these alleged errors, even if admitted, are they material enough to alter this 51%? And you heard the Venerable Akoto Ampao repeat that question over and over again to Mr. Nasiru Nketia, and he couldn't help but admit it. At a point, you saw him denying his own pen drives. You saw his counsel trying to bail him out that they can't tell the authenticity of tapes and therefore it ought not to be admitted. Some of the things that they themselves had admitted.
Mr. Pankuma, all of those things have been explained by Marietta Buropong, who explained some of the things that happened. You had gone to court today trying to run down the credibility of this particular witness, but their argument is that at the end of the day, you ended up actually soaring, and that's the word they use, soaring the credibility of the witness, because first of all, your counsel admits to padding, but then you try to rope in the NDC at a point.
No, first of all, I'm sure everybody who watched the proceedings in court saw clearly what happened and will not come out with the opinion that Mr. Nasiru Nketia distinguished himself in the witness box. Secondly, our counsel did not admit to padding. Our counsel put it to them that in their so-called claim or the alleged claim of padding and the allegation that there's a grand design to, as it were, steal this election for the second respondent, they are beginning to hide parts of that evidence because they realize that it undermines their case. And he drew their attention to the fact that despite the fact that they make this blanket argument of padding in their pleadings, Mr. Nasiru Nketia deletes it from his witness statement because he notices that that allegation of padding as a grand design to help the second respondent cross the mark cannot be sustained, and actually is undermined by the fact that, according to their own allegation, which allegation we are not saying is true, there were places in which, according to their own allegation, they also padded votes. But when he submitted his witness statement, they deleted it. Unfortunately, they forgot that the soft copy was still on the pen drive. And that's why Mr. Akoto Ampao drew their attention and drew the court's attention to the fact that the thing they try to hide from you, the untruths, the falsehoods that they are trying to peddle, they are exposed by the pen drive and the soft copy. And when they attempted to deny it, when Mr. Nasiru Nketia attempted to suggest that he didn't know anything about the pen drive or the soft copy, you saw counsel for the EC also on his feet attest to the fact that he was also seeing the same thing there, and they couldn't deny. Now, in the end, that's how come you heard Justice Apau asking him who put the soft copy on the pen drive, because you have attached it to your witness statement. Indeed, earlier, you heard counsel for Mr. Mahama mislead the court or attempt to mislead the court that it wasn't as part of Mr. Nasiru Nketia's witness statement and that it was part of the petition. And the bench quickly corrected him that no, it is what Mr. Nasiru Nketia attached to his witness statement and swore an oath to support. So unless you haven't been watching the proceedings that have been happening in court today, you are not left with any other impression than the fact that, contrary to what these gentlemen told their supporters to get on the streets, do all that they did, now when they are sworn under oath and are asked to take a calculator and calculate, they come back and say, yes, my lord, that is true.
Two quick things, and then we wrap up, Mr. Pankuma. Regarding the numbers you talk about, Madam Marietta indicates that when they did the calculation in court, we saw the what she says consistently changing or ever-changing figures, which then is described as the manifest errors. And then he says that the video that you play, trying to use that as part of eroding his credibility, actually soared because in those videos, Mr. Asiedu Nketia did only what she calls projections and did not say explicitly that someone had won the election.
And I'm not sure the bench
Wrap up for me on that, Mr. Okonkwo.
Semantics. I'm not sure the bench will be deceived by these semantics. These are learned justices of the Supreme Court. So, a play around words is not what is going to, deceive them. When before them, there's clear evidence that the petitioner, for example, says that there has been vote padding of 5,000 and then now comes to court and chooses to change that to say that these are samples. If they are samples, what is the final figure? And that is why in the end, Justice Apau simplifies the matter and asks them a question. When you did your own coalition, what did you get? Doesn't it strike you as strange that Mr. Mahama, Mr. Asiedu Nketia, and all of these gentlemen announced to the world that they had won this election? Now, when they are under oath and you ask them, what figure did you get? They say they don't know. They didn't bring it to court. They don't have a figure. And it is becoming clear, even to the NDC supporters, I am sure, that their leadership has led them on a wild goose chase, that they knew from the beginning that this election has one clear winner beyond 51%. Because today, as you saw, Mr. Asiedu Nketia, whether you add Techiman South or you take it out, whether you use the press statement on the second day or the original declaration, even despite these alleged errors.
Okay.
When he did his own calculation, 47-51. I'm sure their supporters will have questions for them as the days go along.
Mr. Okonkwo, thank you very much for your time. Kojo Okonkwo, he is a member of the second respondent legal council there, responding to some of the issues raised by Eduji Tamaklo, who has spoken to Joseph Akable at the court. Well, I have lost Joseph, unfortunately, but we'll bring you more, especially the highlights and, the story as it unfolded in our subsequent bulletin.